Right now on Capitol Hill, Acting Attorney General Todd Blanche is appearing before the Senate Appropriations Committee. It is his first appearance since he started leading the Justice Department, and he is facing questions on a number of issues, including the just created $1.7 billion DOJ anti-weaponization fund. Here's an exchange on that with the Democratic Senator Chris Van Hollen.
There's also an individual who, after being pardoned by the president, went on to molest 2 children. And that person actually tried to buy the silence of these children by saying that he would pay them some of the funds that he was hoping to get from your slush fund. Can you commit to making the rules so that that person is not eligible for a payout under this fund?
Well, you're obviously lying in your question, because there's no way that this person committed to that. The slush fund, as you call it, which is not, didn't exist.
I'm sure,
but I can commit.
Mr. Attorney General.
Hey, everyone, John here. So what just happened, guys? In a Senate hearing, Attorney General Pam Bondi exploded when Senator Ruben Gallego raised documented facts about a pardon recipient who promised government money to a child abuse victim to silence her. Bondi accused the senator of lying, and Gallego fired back, "Do not ever do that again." The exchange revealing a law enforcement chief more loyal to the president than to the rule of law. Let's get into every piece of it, because the full picture is even more disturbing than the headline moment suggests. The hearing stretched across 2 days. There were multiple exchanges that revealed fundamental problems with how the Justice Department is being run. There were admissions about prison staffing crises, about the handling of investigations into powerful figures, about the structure of a massive government fund that operates without judicial oversight. And through it all, the Attorney General's behavior.
Don't ever do that again. I am reporting
what again?
What he said. He said on the expectation that he hoped to get some of the funds from a payout. He's been hearing
you said from the slush fund, Senator, and that didn't exist when he said that.
The testy exchange there. Let's bring in CBS News Justice reporter Jake Rosen, who was monitoring this hearing for us today. Good to see you today, Jake. So what stood out to you so far from what you've heard?
We go quite the day for Acting Attorney General Todd Blanche to be in front of this Senate panel talking about the budget for 2027 and what potentially the Justice Department needs to bolster its mission. And at the same time, coming off of yesterday's news of the announcement of this $1.7 billion fund, we should remind our audience it's taxpayer money that's going to be transferred from the Department of Treasury over to the Justice Department for a fund. There will be 4 people appointed by whoever the Attorney General is in the long term, whether it's Todd Blanche or someone else remains to be seen, and 1 person appointed by congressional leadership. We should remind our audience again that Republicans control Congress, so will likely be at least 1 conservative-leaning member of this party that's going to decide who and what and how these payouts are conducted.
Painted a portrait of a department that has been fundamentally transformed from a law enforcement agency into a political operation. The context for this entire hearing begins long before the Attorney General sat down in that Senate chamber. He took over the Department of Justice as a man who had spent years serving as the president's personal criminal defense attorney. He was confirmed to run the very agency that had been building cases against his own client. And during his confirmation proceedings, he made an admission that would come back to haunt him in this hearing. He stated under oath that he maintains a continuing obligation of loyalty and confidentiality to the president based on their attorney-client relationship. Those were his own words, volunteered in a formal confirmation proceeding, not extracted under hostile questioning, but stated openly and on the record. That admission was sitting there, waiting to be used by senators who understood its implications. Before he ever answered a single question in this hearing, the senators who were waiting for him already had that transcript. They already had that statement, and they were ready to use it.
I want to discuss another man, Donald Trump, who is all over the Epstein files. Like former friends, here's the video. Like former Prince Andrew, Donald Trump attended various parties with Jeffrey Epstein. I want to know, were there any underage girls at that party or at any party that Trump attended with Jeffrey Epstein?
This is so ridiculous, and that they are trying to deflect from all the great things Donald Trump has done. There is no evidence that Donald Trump has committed a crime. Everyone knows that. This has been the most transparent presidency. He's the one that asked that those files
I'm reclaiming my time.
be
I got
released.
your answer. You said there's no
President
evidence.
Trump asked
Mr. Chairman,
that
please
those
stop the
files
clock.
be
My time. Stop
signed
the clock.
The legislation. This is
I'd like to
ridiculous.
take my
Time belongs to the gentleman from California.
Okay. I'm going to put up another document from a witness who called the FBI's National Threat Operations Center because I believe you just lied under oath. There is ample evidence in the Epstein file.
Don't you ever accuse me of a
I
crime.
believe you just lied under oath, and this is all on videotape. You said there's no evidence of a crime. I'm showing you, here is a witness statement who called into the FBI's Threat Operations Center.
Senator Chris Van Hollen of Maryland was particularly well prepared. Over the 2 days of testimony, what unfolded was not just a contentious hearing. It was a comprehensive, documented exposure of what the Justice Department has become and how it actually operates under its current leadership. The loss of composure, the personal attack on a senator, the blunt dismissals of serious questions, the evasions about ongoing investigations, the prison staffing crisis that nobody in the mainstream media has covered adequately. All of it matters, and understanding why this hearing exploded the way it did requires understanding what Senator Van Hollen was actually asking about. He was not asking abstract or hypothetical questions. He was asking about a specific, documented, convicted case. The case of Andrew Paul Johnson. Johnson was a January 6th rioter who received a presidential pardon. He was subsequently convicted on 5 criminal counts, including the molestation of children under the ages of 12 and 16.
He drove Donald Trump around in a limo. He overheard what Donald Trump said to Jeffrey on his cell phone. He was so angry, he was going to stop a limo and hurt Donald Trump. And he met a girl who said she was raped by Donald Trump and Jeffrey Epstein. She later had her head blown off, and officers at the scene said that could not have been suicide. No one at the Department of Justice interviewed this witness. You need to interview this witness immediately. Epstein should rot in hell, so should the men who patronized his operation. And as we sit here today, there are over 1,000 sex trafficking victims, and you have not held a single man accountable. Shame on you. If you had any decency, you would resign right after this hearing concludes.
The gentleman has expired.
May I respond?
Yeah, I don't know how you respond. No one can.
I did not
can
ask a
respond,
question,
but
Mr.
he
Head.
doesn't
You're
want
allowed
to talk
to.
about
I did
the
not ask a
horrific
question.
crime in California. He does not want to talk about
I did not ask a
crime
question.
in his
She
state.
can't just
Madam
ad
Attorney
lib
General.
stuff. I did not ask a question.
Committee will.
During his abuse, he used the anticipated payout from a Trump administration fund as a tool to silence his victims. He told a child that he would receive $10 million from the Trump administration as restitution for his January 6th participation, and that he would include the child in his will. This is not a political allegation. This is a documented conviction. It happened. It is on the public record. The court documents exist. The conviction is real. When Senator Van Hollen raised these facts in the context of asking about the anti-weaponization fund, the fund that Johnson referenced in his abuse, he was not making a political attack. He was asking a legitimate oversight question about the connection between a government fund and documented harm. And instead of answering, instead of acknowledging the documented reality of what Johnson had done, the Attorney General called the senator a liar. He accused a United States senator of fabricating facts from a real, documented, convicted criminal case. That is the moment. That is what this hearing became. And what it revealed is bigger than just one bad exchange. Let's examine that moment carefully, because it deserves to be understood in full rather than just described as a dramatic confrontation. Senator Van Hollen laid out the facts of the Johnson case in a clear and measured way. He stated that Johnson received a presidential pardon. He stated that Johnson was convicted of child molestation. He stated that Johnson told his victim he would receive $10 million from the Trump administration and include her in his will. These are facts from a public court case. They are not disputed. They are not in question. They are documented in court records that anyone can access. When Senator Van Hollen raised those facts, the Attorney General did not say, "I am not familiar with that specific case and will look into it." He did not say, that behavior is deeply disturbing and not what the fund is intended to enable. He did not say anything that acknowledged the documented reality of what Johnson had done. He said, you are obviously lying in your question. He attacked the senator's integrity rather than addressing the substance of the question. And then Senator Van Hollen, in a moment that will be replayed for years to come, pointed at him and said, do not ever do that again. I am reporting what he said. That response matters enormously. Senator Van Hollen was not just pushing back defensively. He was drawing a clear line. He was saying, you do not get to accuse a United States senator of lying when the senator is citing documented court records about a case that is on the public record. And he said it clearly, calmly, and directly. The contrast between the Attorney General erupting and Senator Van Hollen remaining steady told you everything about who had the facts on their side in that room. The man with the documented court records was calm. The man who was being confronted with uncomfortable facts lost his composure. Now let's talk about the personal attorney accusation, because this is the thread that runs through the entire hearing and ties everything together. Senator Van Hollen said directly and on the record, you are behaving like the president's personal attorney, and that is the problem here. The reason that accusation has so much force, the reason the Attorney General could not just wave it away, is because of what he himself already put on the record. During his confirmation hearing, months before this testimony, he stated that he maintains a continuing obligation of loyalty and confidentiality to the president based on their attorney-client relationship. Those were his own words, volunteered in a confirmation proceeding, and Senator Van Hollen used those words against him. He was not making a political characterization. He was reading the Attorney General's own prior testimony back to him and asking, given that you said this about yourself, given that you admitted this level of ongoing loyalty to the president, how can you credibly claim to be running an impartial Justice Department? How can you credibly tell this committee that investigations will follow the evidence regardless of political affiliation, when you have already said you owe the subject of potential investigations an ongoing duty of loyalty? The Attorney General did not have a satisfying answer to that because there is not a satisfying answer. The words are already on the record. The loyalty admission is already out there. And Senator Van Hollen forcing that confrontation in public on camera is the most important thing that happened in that hearing room across both days. It exposed the fundamental contradiction at the heart of this Justice Department, a department run by someone who has already admitted he owes loyalty to the president rather than to the rule of law. The Epstein piece adds another dimension to the portrait that emerged from this hearing. When senators pressed the Attorney General on the status of ongoing investigations related to Jeffrey Epstein and his trafficking network, his response was two words: he's dead. That was the lead answer to a question about whether justice has been fully served for the victims of one of the most significant sex trafficking operations in modern American history. He did not address the ongoing investigations. He did not address the victims who are still waiting for accountability. He dismissed the entire line of questioning with two words and moved on. The reporting that emerged from this hearing and the surrounding context painted an even more disturbing picture. Democratic lawmakers expressed skepticism that the Attorney General would actually allow investigations to proceed regardless of political affiliation. Their skepticism is grounded in something very specific and very disturbing that happened in the months leading up to this hearing, something that has not gotten nearly the attention it deserves. The Attorney General gave Ghislaine Maxwell a platform in what was described as a friendly interview. Maxwell is currently serving a 20-year federal prison sentence for sex trafficking minors. She is in federal custody. The Department of Justice, the agency the Attorney General runs, oversees federal prisons. And he sat down with Maxwell in what reporters described as a friendly session where she defended the president without facing any substantive cross-examination. No hard questions about her crimes, no probing of who else was involved, no accountability questions. Just Maxwell, a convicted child sex trafficker, being given a comfortable platform to say nice things about the president while the Attorney General provided the friendly audience. Afterward, when asked whether Maxwell was credible, the Attorney General said he could not say. He could not say about a convicted sex trafficker he had just given an unchallenged interview to. That is a remarkable statement. The man who runs the Department of Justice, who oversees federal prisons, who is responsible for the prosecution of sex trafficking cases, gave a convicted sex trafficker a friendly interview and then said he could not assess her credibility. That is not the behavior of someone who is serious about accountability for sex trafficking victims. That is the behavior of someone who is using his position to protect rather than investigate. The prison staffing crisis is another story within this story that deserves proper attention because it affects real people right now. Under questioning from Senator Jeanne Shaheen, the Attorney General admitted that federal prison staffing levels have dropped to nearly 58% of authorized levels at facilities like FCI Berlin. 58%. That is not a modest shortage. That is a critical breakdown in the staffing of federal prisons where real human beings are being held. Correctional officers are leaving for higher-paying local jobs because of low pay, relentless overtime pressure, and recruitment failures that have been building for years and have gotten worse under the current administration's budget priorities. What does 58% staffing mean in practice? It means the officers who remain are working brutal overtime hours that lead to exhaustion and mistakes. It means there are not enough staff to maintain safe conditions in facilities that are supposed to have controlled, managed environments. It means the people working in those prisons and the people incarcerated in them are both operating in an environment that is structurally understaffed and potentially unsafe. And this is the Justice Department, the agency the Attorney General runs, that is supposed to be managing these facilities. The same agency that found money to create a $1.7 billion fund to pay January 6th rioters cannot find money to staff its own prisons above 58%. That is a policy choice. That is a statement of priorities. And it came out in a Senate hearing because a senator asked a direct question and the Attorney General had to answer honestly about the numbers. That moment, buried in the coverage under the explosive headline, deserves to be understood as part of the same portrait. What is the Justice Department prioritizing? Paying the president's political allies. What is it not prioritizing? Staffing the prisons it is supposed to operate safely and humanely. The Anti-Weaponization Fund confrontation adds another layer to this picture. The Attorney General vigorously defended the $1.776 billion fund as not being limited to the president's allies and compared it favorably to settlement funds created during the previous administration's era. But senators pushed back hard on a specific and critical structural difference that the Attorney General had no good answer for. The settlement funds from the previous administration that he was using as a comparison had judicial oversight. A federal judge was involved in reviewing how those funds were dispersed. There was an independent check on the process. An outside authority with no stake in the outcome reviewed whether the money was being distributed appropriately. That matters enormously because it is what transforms a government fund from a political tool into a legitimate legal settlement mechanism. The Anti-Weaponization Fund, as structured by the Attorney General's own Justice Department, has no judicial oversight whatsoever. It is controlled entirely by a 5-member commission appointed by the Attorney General. His commission answers to nobody outside the executive branch. No judge reviews decisions. No independent authority checks whether recipients actually qualify. There is no outside mechanism for catching abuse or political favoritism in who gets paid. When senators pressed the Attorney General on that specific difference on why this fund lacks the judicial oversight that the previous administration's funds he was comparing it to had, his response was that the fund aims to alter the culture at the Justice Department. Then he pivoted to attacking his predecessor. That is not a policy answer. Talking about culture change and attacking your predecessor does not explain the structural absence of judicial review, and senators knew it. The culture argument and the pivot to attacking the previous administration are what you say when you do not have an answer to the actual question. And the actual question, why is there no independent judicial review of how nearly $2 billion taxpayer dollars get distributed, remains unanswered because the Attorney General could not answer it. The honest answer is that there is no judicial oversight because the administration did not want judicial oversight, because judicial oversight would mean a judge could stop payments the administration wants to make. The hearing also revealed tensions within the committee itself. himself. The chairman, seemingly eager to wrap things up, indicated he was in a particular hurry to get to another subcommittee. He said he would get there sooner if he stopped explaining what they were going to do. That desire to rush through the proceedings, to limit the time available for questioning, reflects a broader pattern of how oversight is being handled. The committee's chairman seemed less interested in thorough examination than in moving on to the next item on his schedule. That is not how oversight is supposed to work. The purpose of these hearings is to hold the executive branch accountable, to ask tough questions, to demand answers. Rushing through the process defeats that purpose. Let's bring this home with a clear understanding of what came out of these 2 days of testimony, because there is a lot here and the full significance deserves to be understood. The explosive outburst is the most revealing moment in this Attorney General's entire tenure. Not because losing composure under pressure is unusual for people in high-stress hearings, but because of what triggered it and what he chose to do instead of answering. A senator cited a documented, convicted criminal case involving a child abuse victim and a pardon recipient who used promises of government money to try to silence that victim. That is an uncomfortable set of facts for the man who oversees the fund that was referenced in that abuse case. The appropriate response, even if you disagree with the framing, is to acknowledge the documented facts and address the question on the merits. The Attorney General could have said that behavior was reprehensible and has nothing to do with how the fund is intended to operate. He could have said the conviction of Johnson is a separate matter from the fund's administration. He could have said almost anything that engaged with the actual substance of what Senator Van Hollen was describing. Instead, he called the senator a liar. He attacked the person asking the question rather than engaging with the documented facts behind the question. That choice to attack rather than answer is telling. It is what you do when you do not have a good answer. And it happened on national television in a United States Senate hearing room. That exchange is permanently on the record. It happened. The cameras were running. The transcript exists. And it defines how this Attorney General's tenure will be remembered, not as an independent law enforcement officer doing a difficult job under political pressure, but as a loyalist who snapped when confronted with the consequences of his own loyalty. The personal attorney accusation is not just a rhetorical attack. It is a documented description of a structural problem. Senator Van Hollen's line, "You are behaving like the president's personal attorney, and that is the problem here," is grounded in the Attorney General's own prior sworn testimony. He said he maintains a continuing obligation of loyalty and confidentiality to the president. That statement exists. It is in the confirmation hearing record. What we have seen in the months since this Attorney General took over the Justice Department reflects exactly what that loyalty obligation looks like in practice. He created a nearly $2 billion fund to compensate the president's political allies using a government mechanism that bypasses congressional approval. He responded to questions about Epstein accountability with, "He's dead." He gave a convicted sex trafficker a friendly platform and then said he could not assess her credibility. He was accused in a Senate hearing of running the Justice Department like the president's personal law firm. He called a senator a liar for citing court records about a child abuse case connected to the fund he oversees. That is the behavioral record, and every single element of it is consistent with what you would expect from a man who said under oath that he still owes his former client a continuing obligation of loyalty. Senator Van Hollen is not speculating. He is describing what is documented. The Ghislaine Maxwell interview is the piece of this story that should be generating far more outrage than it currently is. Think about the basic facts. Maxwell is serving 20 years in federal prison for sex trafficking minors. She is in federal custody, meaning the Department of Justice, the agency this Attorney General runs, has direct authority over her detention. And he sat down with her for what reporters described as a friendly interview, where she defended the president without facing any meaningful cross-examination. No hard questions about who else was involved in Epstein's network. No questions about clients and associates who were never prosecuted. No questions about cooperation with ongoing investigations. Just Maxwell, the woman convicted of facilitating the abuse of children, being given a comfortable, unchallenged platform to say positive things about the president. Then when the Attorney General was asked afterward whether Maxwell was credible, he said he could not say. The man who just gave her an unchallenged interview said he could not assess whether she was credible. The Democrats on that committee, who pointed out that the Justice Department is withholding half of the documents legally required by transparency legislation, are looking at the Maxwell interview and looking at the withheld documents and seeing a pattern of protecting rather than investigating, a pattern of giving comfort rather than accountability, and they are right to see it. The prison staffing crisis admission is the quiet scandal buried under all the dramatic exchanges, and it deserves to be treated seriously. 58% staffing at federal prisons is a humanitarian and public safety failure. Not a budget footnote, not an administrative challenge, a failure. Correctional officers leaving because pay is too low and overtime demands are too high is not a mystery problem without a solution. It is a resource allocation problem. It is a question of what gets funded and what does not. In an administration that found $1.776 billion to create a fund for January 6th rioters, the argument that there is no money to properly staff federal prisons is not credible. It is a statement of priorities. The people incarcerated in those prisons, regardless of what they did or why they are there, are in the custody of the United States government. That custody comes with obligations, safe conditions, adequate supervision, a staff level that allows the facility to function as it is supposed to. 58% staffing does not allow for that. The senator who forced that number out of the Attorney General on the record did something important because now it is documented. Now it is part of the congressional record of this administration's management of the Justice Department. And it sits alongside the fund and the Maxwell interview and the explosive outburst as part of the same portrait of a department that is being run according to a very specific set of priorities. Those priorities are not about the safety of the people in federal custody or the integrity of federal investigations. They are about something else entirely. The bottom line from this Senate hearing is clear. The Attorney General, the former personal defense attorney and current top law enforcement officer in the country, lost his composure on camera in front of the United States Senate and called a senator a liar for citing documented court records about a child abuse victim who was told to stay quiet with promises of government money. He was confronted with his own prior sworn admission that he still owes the president a continuing obligation of loyalty and confidentiality while running the nation's top law enforcement agency. He responded to questions about Epstein accountability with 2 words and changed the subject. He admitted that federal prison staffing has collapsed to 58% of authorized levels while his department found money for a nearly $2 billion political reward fund. He could not explain the absence of judicial oversight in that fund without deflecting to a predecessor attack. And it emerged that he had given a convicted sex trafficker a friendly, unchallenged interview where she defended the president and then told reporters afterward that he could not assess whether she was credible. All of that happened over 2 days. 1 hearing, 1 man running the Justice Department of the United States. And that man, when confronted with the child abuse court case connected to his fund, snapped at a senator and accused him of lying. That is the documented record of this Attorney General's first congressional testimony. It is a portrait of a department that has been transformed from a law enforcement agency into a political operation, run by someone whose primary loyalty is to the president rather than to the rule of law. The coming testimony will add more to this story, and it is essential to pay attention to every word.